Welcome back to the virtual orientation for the incoming class in the English Language JD program at the University of Ottawa. In this podcast, I discuss the issue of oral advocacy with Professor Stephen Blair, and we focus both on the virtue of oral advocacy for those in legal practice and also some of the skills and aptitudes associated with oral advocacy. I began by asking Professor Blair about his professional career.
Well, I've been teaching at the law school for over 10 years now. I teach several courses, contracts in first year, and then upper year courses, commercial law, evidence, trial advocacy, and appellate advocacy. And I also coordinate the Nelligan O'Brien Payne first year moot competition, which is held in November of each year.
And you were in private practice before coming to the law school?
Yes, I was in private practice for about 15 years at the firm of Osler, Hoskin and Harcourt in Ottawa. I was primarily involved in a commercial litigation practice, although I did other areas of litigation such as insurance, defense work, some municipal law work, and some plaintiff personal injury work.
So this podcast is on the concept of oral advocacy. What do we mean by oral advocacy?
Well, I think traditionally oral advocacy connotes a lawyer appearing in court or before a tribunal to plead or argue their case and present evidence to the body who's hearing the matter. However, oral advocacy has a much wider role in being a lawyer that goes well beyond traditional court type work.
So, for example?
To be an effective lawyer, whether you're involved in court or whether you're involved in solicitor's work, office work, transaction type work, you have to be an effective advocate of your client's position and the positions that you want to take to people on the other side of a transaction or a court case if that's where you end up. So certainly skills that you learn, advocacy skills which you learn in the more traditional sense can be applied to other areas of law.
So it's not just an ability to present your views in front of a formalized tribunal, it's also to be able to speak persuasively in a transactional context or any other context where you need to advance a perspective?
Well, absolutely, and by acquiring basic advocacy skills, which might be more related to a court type proceeding, then these are easily transformed into other areas of law. You know, you learn the language and technique of lawyers, which no matter what type of work you do is really not that different from area of practice to area of practice.
So a lot of people are nervous about the idea of public speaking. Are there skills and aptitudes they can develop to help them with their oral advocacy?
Well, I think in most cases, most students are, I don't want to say terrified of public speaking, but they're a little nervous about when they embark upon their initial advocacy or public speaking in a law school context. And I guess what I'd say is first of all, you're not alone. That every law student there's ever been has felt that way, and what we try and do is move you into a little situation where you're more comfortable in speaking.
And how do we do that?
Well, we offer a number of courses that are aimed at improving your oral advocacy skills, and I guess that begins probably in first year with our Nelligan first year moot competition, which is a voluntary competition for first year students. It's not part of the curriculum, but well over 50% of first year students take advantage of that. And that's a moot court exercise which takes place in November, so 8 or 9 weeks after you begin law school, you are on your feet arguing a case. And we wouldn't do that if we didn't think that students at that point in time could do it, and most students perform very well.
What's a moot court?
Well, a moot court is I don't want to say it's a pretend court, but it's not a real court, but it's run like a real court. So we hear cases in a moot court in law school because we argue them like they are real cases, but obviously they have no real outcome because they're not going to affect anybody, and they're done for practice purposes, and sometimes for competition purposes in upper years.
So you've been teaching oral advocacy in various capacities for a number of years and making all sorts of comments and observations for and to students in terms of improving their skills. What are some of the common shortcomings of someone starting off in this area and that you might be able to share with our listener?
Well, I guess I look on it the other way and say that most students do remarkably well in the oral advocacy program. So it's not a case of saying that there are many shortcomings. Some people start off and they're naturally more adept at this type of exercise, but students who have less experience or are not so as much inclined to speak in public, they improve rapidly through the exercises that we do. And I should also add that in first year, we also have the mandatory ADR program in January, which involves advocacy exercises in terms of negotiation and attempts to resolve disputes. And then in many of the small group classes in first year, they run their own moot court exercises in say March, where students are required to prepare for and argue a case in class. So those are other opportunities in first year, and then we have a whole range of opportunities in second and third year.
Some people use video to analyze persons speaking in advocacy courses. Do you use video?
I don't use video, although I think it is very helpful. I find it somewhat cumbersome to use in the sense that we don't have built-in video facilities at our law school that are readily accessible. However, if students want to bring their own computers or devices these days and record themselves, then of course they are free to do so. I would like to build something more formal into the courses I teach, but at the moment I'm not doing that.
So what kind of comments would you make after someone had made a presentation? What would they expect in terms of feedback?
What we tend to do is provide feedback in two ways. One way is, well, how did you do in your presentation? So are you standing up straight? Are you making eye contact with the witness? Are you talking too fast or too slow? Things of that sort. So just basic skills that as an observer you can make when anybody speaks in a public setting. And then secondly, we would look to some degree at the substantive content to see whether or not the student is addressing the right issues in the presentation that they're making. We're not terribly concerned about whether the what's being done is right or wrong, but obviously we want to make sure you're moving in the right direction and asking questions that are pertinent or providing submissions which are pertinent to the issue that's being addressed by the exercise.
And it's often said, I think, that a lot of being an effective advocate is preparation. Would you agree with that?
Well, I think that is true, yes. You hear that universally. People say that preparation is important, knowing every important and less important detail of the case that you are presenting to a court or tribunal, or knowing, again, all important details and less important details of a transaction which you might be involved in. That goes a long way, and you add that together with basic skills in terms of how to make the presentation in a formal way, and you can move very effectively forward.
Is there any other advice you'd have for students who are interested in developing their oral advocacy skills, things that they can do not just in the first year program, but perhaps in upper year and or perhaps even in extracurricular activities?
In terms of upper year courses, the first thing that people can do is they can try out for a competitive moot. We participate in roughly 15 competitions involving other universities in a variety of areas of law. And these competitive moots are very demanding exercises, both in terms of the written submissions that you have to make, which again is part of advocacy on the written side, and secondly in terms of the oral presentations you have to make. So that's a very effective way to develop skills. And then we offer a variety of courses as well. We have courses in trial advocacy, both on the civil side and on the criminal side. We also have an appellate advocacy section where we teach appellate skills. And then there are other advocacy opportunities. There is a negotiation course that you can take. There are negotiation competitions that you can enter into. And I believe in labor law as well, that there's an advocacy component to one of the labor classes. Perhaps it's advanced labor, where they involve themselves in an arbitration type of a proceeding. Now, on the other side, what else can you do? I think people often say, well, you go to court and watch cases being argued, and that is true. Some of that is useful. However, the problem with going to court is that unless you're really involved in the case, then oftentimes it's not that interesting. So I don't expect people to be going to court every week to see something that's going on, but the opportunity to see appeal work being done at the Supreme Court of Canada is unique to this school, and so I'd encourage students to go and watch cases in which they have some interest in the outcome a few times during their stay here, and then to attend some of the trials that take place at the courthouse at 161 Elgin Street. It's a bit of a hit and miss process in terms of whether or not you're going to walk into a case that is interesting or not, but at least spend a little bit of time there. And both courthouses, the Supreme Court and the local courthouse, are close to the law school.
Thanks very much, Stephen.
Okay, you're welcome.